A similar approach was adopted by the Supreme Court of India in Rajarampal versus the Speaker, in which MPs were shown on television accepting money for posing questions in Parliament. The MPs attempted to approach the courts for relief after being expelled by the Parliament. The Parliament asserted that the courts lacked jurisdiction and that the Parliament alone had the exclusive right to discipline MPs, a right in respect of which they were not answerable to the judiciary. This was, of course, an assertion of privilege. A majority of the Supreme Court of India held that if an allegation is made by a citizen that he has been unconstitutionally deprived of his fundamental rights as a result of the exercise of a parliamentary power or privilege, the court has a duty to examine this question, notwithstanding the claim to privilege. And that, colleagues, is, I think, the short point. Our Constitution in Section 55 is in terms similar to the Indian Constitution in Article 105. And it provides that parliamentary privilege is subject to the provisions of the Constitution. The precise words used in the Constitution are that subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of the Senate and the House of Representatives, there shall be freedom of speech in the Senate and House of Representatives. A complicated issue arises in the sense that Section 55 also provides in Section 55(3) that in other respects, the powers, privileges, and immunities of each House and of the members and the committees of each House shall be such as may from time to time be prescribed by Parliament after the commencement of this Constitution, and until so defined shall be those of the House of Commons of the Parliament of the United Kingdom and of its members and committees at the commencement of this Constitution. The House of Representatives Privileges Act can arguably be said to be a prescribed act under Section 55(3), and that is so notwithstanding the fact